Good morning, everyone, and welcome to today's Case Metrics webinar. We're going to give everybody a couple of minutes to join. I see participants are logging on. We'll give you guys a few more minutes to do that. We're very pleased to bring to you today Lauren Fraser and Ken Levinson, who are co-hosts for today's webinar. This one's going to be fun. We want it to be super interactive. They're going to be handing off to each other. We want people to log questions all along the way. Ken and Lauren are making this super fun in that they're fine with you guys logging questions along the way, and we'll be monitoring the Q&A for that. If some people are joining and they're having any sort of technical issues, feel free to log those in the chat as opposed to the Q&A. And we have someone on board that will be glad to provide technical assistance if you need that. So we do have a lot of people still joining, and let's see. We can go ahead and get rolling. So first of all, let me introduce today's panelists. First, we have Lauren Fraser. She's a partner with Jaberbaum, Wergraft, Hicks, Kahn, Wickstrom, and Sinnis in their Sparta, New Jersey office. And Lauren focuses her practice primarily in spine and brain injury cases. That's what she's known for. She handles truck and motor vehicle crashes and also premises liability cases, as well as running focus groups and jury research. She serves on the faculty for both NJAJ and AAJ in their Case Plus program, facilitating focus groups across the country. Over the past 19 years, Lauren has obtained some of the largest verdicts in New Jersey on soft tissue injury cases, including 7- and 8-figure verdicts. She will change the way you look at evaluating soft tissue cases. In her spare time, she's also the owner of Trinity Studios, performing arts studio, and she is the producing artistic director of the Black Cat Theater Company of New Jersey. She's a best-selling author of a young adult fiction series, Trinity, and is currently working on publications for lawyers. I'll post her contact information in the Q&A, so if anyone needs to reach her, they'll know how to do that. We also have our co-host, Ken Levinson, who's founding partner of Levinson and Stefani Injury Lawyers, and we all know him as a nationally recognized trucking attorney. Ken is currently the chair of AAJ's Trucking Litigation Group, and he's based in Chicago. He handles catastrophic injury, truck and auto collisions, and co-authored Litigating Major Automobile Injury and Death Cases, published by AAJ and Thomson Reuters. Fun fact, Ken's the guy to call for a recommendation of the best restaurants, no matter where we're traveling across the country. So he wears multiple hats. I'll also have Ken's information posted in the Q&A, so we'll be ready to go with that. Without further delay, I'm going to hand it off to Lauren and Ken, and thank you very much.
All right, thank you, and thanks for having us. I'm going to share my screen here. If I can get in there, there we go. Perfect. All right, we've got slides.
We got slides.
All right, see, step one, very good. Well, welcome everybody. Thanks for having us today. And Ken, why don't you update the title of our program now, as you've told me.
Will do. So now we've gotten a couple of verdicts, one particular substantial verdict. So our title now is over 500 million in verdicts. So we've been so honored to help some of the best trial lawyers in the country, and also with our cases. So we got to change the name of our talk from now on, Lauren.
Yeah, that's good. That's what we're here for, right? We're here to keep bringing successful verdicts for the folks that we work with around the country. So let's just get started on this. So who are we? You heard our professional bios, and you heard a little bit about some of the things that we've done. But one of the things that Ken and I have in common, besides incredibly huge appetites for really good food, is our families. And one of the things that sometimes we lose sight of when we are working up cases for our injured clients is that we get sometimes caught in the weeds a little bit with injuries and liability issues and regulations and all that kind of stuff, and we forget that the story of the case is really the story of the family. So we wanted to share a little bit, some pictures of our families, And Ken and I, we travel all over the country speaking to lawyers, just like you guys, from, through other organizations. But really the message is really that we're here to help. We're here to help you pinpoint the issues in your cases that need to be addressed so that you can maximize your settlements and also your verdicts. So that's just a little bit about us. So what we're here to talk about today is really the things that we learn going around the country and conducting these focus groups for lawyers. So we're going to go through our favorite list of the common traits of exceptional trial lawyers. And Ken, why don't you start with this one?
Well, the fact that you all are on this webinar speaks volumes. The best lawyers in the country that Lauren and Beth are always trying to improve and learn. And the fact that you're listening and trying to improve speaks volumes. It really does. And my quick example is I was able to work with one of the best lawyers in the country based in Chicago, former president of AAJ, Illinois trial lawyers. And he called me out of the blue one day and he said, I need your help. And I'm thinking, it's like Michael Jordan asking me to help him with his basketball game in his prime. But the lesson I learned was he always wants to tweak and improve and get better despite his record verdicts for decades. And I think that's one of the traits we see in the best lawyers we work with. Always trying to learn. They're taking areas that aren't necessarily specific to trial work. We have some of the best books from AAJ or trial guides, but they're learning about psychology and decision-making, and they're reading and trying to storytelling and piece together things that they can bring to the table to help their practices, but more importantly, help their clients.
Mm-hmm. Yeah, absolutely. And, it's one of those things, Ken, where we're dealing, we meet these people and it's just, it's a constant barrage of, what about this? What about this? What do you think about this idea? What do you think about that idea? And, sort of sometimes just, wading through the weeds of information. But the idea is that the more stuff you can find out there that may or may not be legal law related, whether it's sociology, psychology. We have a number of books to recommend too. They're going out of their way to absorb as much information and knowledge that's out there as possible. But one of the other things, and this is kind of my favorite thing, because I early on as a nervous, anxiety-ridden baby trial lawyer, I was, considered sort of a negative Nelly because I would be worried about, all of the ways we're going to lose our case. And it really turns out that, later on that sort of method of my own neurosis was that, when we're looking for the landmines in our cases, the things that are going to torpedo our success and more importantly, our client's success later on, we are actually on the winning side. So that's something that, we found that other exceptional trial lawyers, and not that I'm considering myself an exceptional trial lawyer for feeling this way, I think I'm just neurotic, but they're really looking for what is it that a jury is going to find either objectionable or offensive that's going to torpedo my case and my ability to succeed for my clients. So always looking for landmines. And another thing that they do is they talk to everyone about their cases and about the issues in their cases. One of the things that a friend of mine used to tell me that he would do is he would go to the hair salon and, he didn't go to a barber, he went to the salon, so he's very fancy, but he would talk to the woman cutting his hair and the woman washing his hair and talk to the ladies in the area to see what they thought and some of the information they thought was important in his cases. And he was really treating those sorts of moments in life as mini focus groups. So they talk to everyone, whether it's, strangers, people at the bar, if it's, family members or formal focus groups, they talk to everybody about their case and they ask for help. I mean, that's, one of the things that, Ken and I will get a call and it's sort of this exasperated, hey, I'm not really sure what we need to do about this issue. And, what do you think? And I always say, well, nobody really cares what I think, and then at this point, my daughter is 11, almost 12. I know nobody cares what I think. So, asking for help is all right. Let's find some of those people out there that could, give you the answers that you need. And for us, that would be, finding a focus group and putting that together. And the final point here is that, the lawyers that we find, and Ken, you can agree or disagree with this. I find that they are the most humble attorneys or professionals out there, right? I mean, there's not even a humble brag involved, right?
Absolutely. And frankly, the easiest lawyers we work with are the most successful. It seems almost counterintuitive because you think the high level successful trial lawyer who, she's gotten dozens of 8-figure verdicts like Lauren might be more challenging, difficult. And I find that the exact opposite is true.
Yeah.
They're humble, will, like Lauren alluded to, ask for assistance and help. It's fascinating dynamic. And they're just have this mindset of improvement. But one thing I want to talk about with landmines, and the question I think great lawyers ask, and I think Lauren and I, when we work with fellow trial attorneys, ask is, if the jury believes it, how can I lose my case? Like, what is the landmine? What is going to kill our case? And I kind of look at it very simply two ways. One is legal, actually the legal issues, the jury selection, jury charge, and things that we learn in law school. And sometimes that's the key, proven approximate cause, or even standard of care violations, or in a truck case, just proven the trucking company was negligent, or maybe a broker shipper entity had some responsibility. Then I call the other landmines the non-legal stuff, things they don't teach in law school. It could be the likability of your client, or maybe the likability of the poor defendant driver who just seems like this little old lady who can walk into court with a hot apple pie and everyone would say, of course. I mean, things that maybe you don't learn in law school, and you have to think about, what is it that's going to hurt your case? And also, more importantly, perhaps, how are we going to overcome that?
Mm-hmm.
And one thing I have to make a shout out, and this goes with this slide about learning and improving and getting more information. For those on the webinar who have not heard of Case Matrix, reach out to Kim White, reach out to others. I have a little blurb I prepared. I want to read. Case Matrix is a settlement and verdict database used by thousands of attorneys, primarily in the southeastern United States, but they're collecting trucking data across the country. They update the database every 15 minutes, believe it or not. And attorneys use the data to effectively negotiate fair, just settlements for their clients. They've won several national awards in the legal technology space and gained the attention of thousands of attorneys that rely on their data as full-time subscribers, but they also offer a la carte searches. Again, I encourage you to reach out and maybe take it a step further, reach out to find out what cases settled or verdicts that remind you have similarities to your cases, and then call the lawyer handling the case. I think most trial lawyers, again, we talked about how humble and helpful the best lawyers we see are. Find out who tried that case that got a really nice substantial verdict. I won't use that word the insurance company uses about fair, just verdicts, but reach out to that trial lawyer, see what they did, what expert, what metaphor or story resonated with the jury. So again, Case Metrics, they're fantastic to work with.
Great. All right. Let's go forward here. Hang on. There we go. Okay. So let's talk a little bit about some of the things we've learned about mistakes lawyers make in their cases. And Ken, why don't you start with this one? Because this is like one of your favorite areas.
One of my favorite areas. And the mistake number 35 made on this slide is he let my son, my little guy, who's a senior in high school, get the ball. So anyway, we read books and we hear famous trial lawyers give these wonderful closing arguments, and they have a theme. It could be, and my favorite one these days is profits over people, profits over safety. And it could be a great theme. It could be wonderful for your case. But we worked with a lawyer recently, I did, and he was working on a fall case at a grocery store, and it was a tough liability case in the focus group. he kept using that phrase and it hitting people over the head, and it wasn't the case for that theme. So make sure it fits. If you're surely, if there's a decision by corporate headquarters that we're going to save some money, like the old time famous Ford Pinto case, and it's truly profits over people and safety, have at it. That's wonderful. But in a rear end collision where there's just a mistake by a driver, or a lot of a slip and fall or premises cases, be careful about that having the wrong theme. And again, test that. Use Lauren Fraser or someone to help you with focus groups to get that theme that resonates and fits with the case you're working on. Makes sense?
Yeah, no, absolutely. And, along the same lines of, is using the right theme, the more appropriate theme, jumping to number 3, when we use rule violations and mistakes that don't matter in the case. I mean, you might have this great trucking case with, some sort of, run-of-the-mill type violations in there, but then you're like, aha, there's also an OSHA violation, and you start harping on those issues, and now your jury's like, what are we talking about? That doesn't matter, and you're kind of complicating the case needlessly. So that's another sort of area that sometimes we run into, is that we've made a nice long list of all of the violations and the mistakes that this company or this trucking company or this doctor made, but if they don't matter, it's most important to focus on the things that do matter in the case.
And let me, can I chime in?
Yes, please.
People talk about speed a lot in these cases, especially the truck cases we work on, even an auto crash case. I can tell you in all the focus groups we've done, hundreds of them, if someone's going 67 and a 65, nobody cares. I mean, if your theory is they're going 2 miles an hour over on this highway and that's your focus, be careful. I've had multiple people in focus groups say, well, if it's 65, legally you can go 70, right? Which, think about that for a second. But if it's a petty, you never want to be the lawyer that looks at rule violations or safety rules as petty, and you're just, the metaphor I get a lot is, it seems like they're just throwing all to see what sticks. And they're being too lawyerly and technical. If that's your theory, you got to rework it. You got to be careful. Sometimes getting 1 or 2 serious rule violations that matter is much more important than getting 8 ticky-tacky technical violations that don't really matter. And you lose your credibility from the key part of the case. You want to simplify it. And the way I look at rule violations, and I love Lauren's insight on this, is it common sense? Does it make sense? Even if you didn't know what the rule was, is this resonate with a regular person? Because if it's too technical and too wordy and hard to understand, I don't think people are going to look at a defendant and be critical of them if it's too technical.
Well, one of the things, Ken, that I find in a lot of my focus groups and even a lot of jury verdicts is that when it comes down to it, it's, there are rules and then that are on the books and we're all supposed to be following, but then there are juror rules. And the jury is really the body of people that we really have to care about what rules they think are important and what rules they consider. And, that kind of goes to number 5 with burden of proof, is that, in a lot of our cases, the burden of proof is, is it, a preponderance of the evidence. And, we find that no matter what, and we just did a focus group a couple of weeks ago, and no matter what, even when I say, but does it change your opinion to know that, you don't have to be sure, it has to be more likely true than not true? No, it does not, because jurors have their own rules. They come up with their own way of considering the burden of proof and what they have to follow to deliberate. And so, as much as the judge, can tell them, and we can tell them, this is all you have to do. You just have to, it's just about the scales. It doesn't matter. They want to be certain in a lot of cases. They want to be sure. And so considering those things, finding the rule violation that is common sense. Like, does that make sense? Can you drive your car into the back seat of someone else's car? no, you cannot. That's an easy one, rather than using the technical, whatever the statute is, in a particular state for the motor vehicle violation. I mean, the logical, answer is, no, you can't drive into someone's backseat, just not the rule. So getting those ideas is really something that we like to get from the focus groups, because they come up with their different, perspectives on things, and unique ways of coming to their final deliberations. And, a lot of people don't realize that I'm in New Jersey. I practice in New Jersey primarily, and we don't really have, although it's coming, we don't really have true voir dire, or as my friends down south say, voir dire. And so I had tried to help lawyers out of state to create those voir dire questions that can help vet and sort of frame their case right from the time that the jury is impaneled. That's an important time, I think, to start working on those things. But back to just a second, I want to go back to too technical. Besides rules just being too technical, when we start pontificating and pretending that we are the expert in medicine and all things brains and spines and whatever, we lose our juries. And Ken, if you agree with me on this one, or disagree with this one, in a lot of cases, especially, medical malpractice, again, it's really about fine-tuning your knowledge and what the experts are going to say, and creating a story that is common sense and makes sense. Can you cut off the wrong limb when you're supposed to cut off the right limb and you cut off the left limb? It has to be much more simple than the medical technical things. And the reason why is not because the jurors are idiots, because they're certainly not because they're lazy, they're certainly not. It's because our brains are not designed to sit there for hours on end listening to medical testimony when it's not our normal course of living. So becoming, when we become experts in certain medical areas, like I know a lot more than the average bear about the spine or the brain. However, when the words are coming out of our mouth and they're technical, we've lost the jury. And further, I think even to some degree, when the questions that we ask our experts are too technical and the expert starts answering in a technical medical way, our juries are missing the point. So that's a mistake that I see a lot, right, Ken?
Absolutely. And let me give a shout out. There's a famous trial lawyer based in New York named Andrew Busen. And I remember talking to Andrew one time about a case, and he was brought in. He's a great trial lawyer. Sometimes lawyers bring him in halfway through. And he's gotten some huge verdicts in a variety of contexts, one of which are abuse cases, school abuse, other types of cases. And he was working on this case, and he got brought in late, and the whole theory didn't resonate with Andrew, and he changed. He said, look, this is not going to work. And I think a great lawyer looks at a case, and a lot of lawyers would have came in and said, yep, that's your theory, that's your expert, that's where we're going with presentation at trial. He changed the whole thing, and I think he got another phenomenal result for him. So again, don't be afraid of changing your theory, changing your approach if it's not resonating, if it's too technical or otherwise. I think I see a question in the chat. H. Lee talks about specific tips for trial stage fright, anxiety, and he mentions improv, and I want to follow up on improv. And Lauren's got a theater background, so she's the expert in presentation, storytelling, theater. But I'd recommend an improv course in Chicago. We have Second City. I did a Second City course, and it was really a great, I did it for fun, but I thought it turned out it was extraordinarily useful for what we do for a living. And one of the ways is jury selection, or even an examination of a witness where you don't have control, like a cross or, and the two most important words I think in improv are yes and. So it keeps the conversation, or it keeps the scene going in improv by saying yes and, as opposed to but or stopping the scene. Because in jury selection, you want to continue the conversation, ask questions, and get folks talking as opposed to cutting it off. So doing improv exercises, techniques, take an improv class, I think it helps you with the stage fright. And also, I know some lawyers will do sort of mock or practice jury selection with a jury or the focus group. And I think that's another technique to use, because you've talked to non-lawyers, strangers about your issues in the case that concern you or that you're going to talk about in jury selection. And you've had some practice. So two of my tips, but I'll leave it to the expert Lauren to add better insight.
No, I totally agree with you. In fact, we offer acting classes for professionals, really to get people really comfortable in their own skin. You know, it's not, for me, I grew up on the stage, I grew up performing. So, you know, this is sort of second nature, although, you know, no matter what happens, I walk into a courtroom and like, I'm sweating and, you know, freaking out because that's just, you know, my natural being. But those are really great tips. Improv, certainly. And then, you know, even getting yourself involved. I know this is kind of a pitch, but getting yourself involved in theater or community theater, getting on stage outside of your comfort zone and taking on a role where you have to immerse yourself in a character, where there might be emotions, there might be a backstory, and really getting yourself involved with sort of becoming another person. And what I find is my theater background has always assisted me in finding the story of my client's life, and being able to step into their shoes and understand, you know, why, you know, for me, I don't have a problem picking up, you know, my grandchild, but, you know, to understand why that's such a big deal, or I don't have a problem at work not being able to take something off a top shelf, but why that would be a problem in someone's life and why that would affect them in so many different ways beyond physical. So those are my tips. Definitely improv. I think improv is just a lot of fun too. But you know, stepping into the shoes of another character, either in a play or something like that, is a really great way to you know, to hone your skills in terms of presentation, but also, you know, kind of figure out how to quell your nerves and deal with the adrenaline of being nervous. I just have nervous energy all the time. So as Ken knows, I'm always bouncing off of walls and things. Kim, were there some other questions that you want to jump in and ask? Oh, I think you're on mute there. Oh, I think Kim, I think you're muted there. There you go.
Getting back in there. Okay. First, I love the questions and answers about anxiety, because it's something that people are too shy to talk about, but it happens. And I always thought in my law firms that it was good for people on a regular basis to do some form of public speaking, whether it's just doing an introduction to someone, just being familiar with the mic and learning to have conversations with your audience, as opposed to just being the one and only performer up there. So I love that you're dealing with that. H. Lee was also asking for tips and tricks defense has used against you. Anything that you felt that sort of tripped you along the way?
Well, from a character and acting perspective, many years ago, and I think he's since passed away, there was an adversary. His name was Floyd. And literally, like, we used to joke that he was like Uncle Floyd. But he was this kind of folksy guy. And as an adversary going through the case, he was just abominable to deal with. And I'm a pretty laid back, easygoing person. And I just remember just being very frustrated by him all the way through. We didn't settle the case. It should have been settled. And then we get to trial. And Uncle Floyd, who is this sharp as a tack, you know, sort of this bombastic character, all of a sudden transforms into this character of this folksy old grandfather. He's walking into the tables, he's dropping his glasses. It was like, and the jury were watching their faces and they're just like, oh, they're just eating it up. And it was one of those things like that after a while, I think we actually had to say something to the judge, and the judge was like, can you just, you know, pull it together, Floyd, like, you know, get yourself, you know, situated. And he started making comments sort of against him on it because it was getting to be too much. But I just remember that's one that sticks out in my head, because there's really nothing you can do about that other than just sit there and be yourself. You know, I'm not gonna, if I trip, it's because I tripped. I'm not putting on an act. So that was one thing that I just remember, just from a, you know, non-legal perspective, that there really wasn't much we could do about it other than hope the judge would pick up on it and say, you know, cut it out. Enough is enough already. How about you, Ken?
Yeah, in terms of defense tactics, perhaps, is that
Yeah.
what we're talking about? So I think overall, the thing that defense lawyers do is they make the case complex. So we had a truck case recently that on seemingly easy case, it's a rear end collision. We sue the motor carrier and the driver. Next thing you know, the defense brings in about 10 third-party defendants, and they made it a product case. They made it against a crash avoidance system. They made a mechanical case. They made a broker case. They made it. The mistake a lot of us make, and I'm certainly guilty, is falling into the trap of fighting every battle. Stick to your theme. We had a dash cam video that showed split screen driver and the scene. That was my focus. Let them be distracted. Let them distract the jury. Let them distract other witnesses. We have the video. Look at the video. That's it. If we fall into a trap of wanting to combat every argument they make, it's usually a losing strategy. I find, and I think Lauren agrees, complexity, confusion, difficulty is the best friend of the defense lawyer.
Oh, absolutely. And this is what they mean to do. I mean, keep in mind, the only people in the room generally who are billing and making money that day is the defense attorney. So I totally agree with you. This is what they mean to do. And it's, to obscure the truth of the case. And one of the things that, and I'm actually just similarly, I'm like, you just give me like sort of like PTSD. I'm working on a case, just came in, where my client's house blew up because they had the wrong part put onto their boiler and it blew. And, bad injuries, nobody's head fell off or anything. They're okay, but, pretty bad injuries and property damage. And, as soon as this case, we started, notices of claims started going out, it became so much more than that. It's a products case. It's all these different things. And one of the things that I tell my clients before we go into deposition is just remember, they're going to ask you a lot of questions, and a lot of the questions that they're going to ask you, you're going to be kind of rolling your eyes in your head because they seem so tedious. And who cares? Like, who cares what color shirt you're wearing, or, whether you're carrying your purse on your left side, your right side? It doesn't really matter, because just remember, at the end of the day, this wasn't your fault. And so I find that I kind of keep that mantra in my head when I'm dealing with these cases, just like Ken, in that, look, this isn't my client's fault. They didn't blow up their house. We know that. I mean, if it is, it's a different story, but we know they had nothing to do with the explosion in their home other than turning on the heat as normal. So, when we remember that, the issue is not, all these different things that they're throwing out there, and this part and this part, and it doesn't matter. It really, what it comes down to is those very simple issues, whose fault was it, why and how, and basically, what are they going to do about it? I mean, those are the things that the jury wants to know about too. So those issues are the way that we kind of keep focused on these kinds of cases, because, the defense, they love to do it, right?
And I'm so glad you guys are bringing this up. I'm going to butt in just for a second, because I'm thinking of one trial I had. It was probably 15, 20 years ago, but we did work with professionals to talk about home bases.
Mm-hmm.
And in every case, you can make it as simple as having 3 home bases. So no matter what the defense throws at you, you tie it back to one of those and hit it head on. They keep trying to talk about X. This case is about these 3 things. So bring it back, put it into one of those categories, and talk about how that doesn't fit. That's not what this case is about. And to make it super simple, introduce the 3 home bases early on. Keep coming back to that. And that way, all along, both you and your jurors are realizing when somebody's getting out and trying to throw in some new issues that really aren't relevant to your case. And another thing, makes you and your client look like the good guy that you are, because you're not trying to turn your case into something that it's not.
Exactly. That's exactly. Well, go ahead, Ken, you were going to say something?
No, I agree. I was just looking at our list, and I think 8's important as well, right? Not vetting discovery issues before trial.
Yeah, we should actually talk about that in terms of our focus groups. And that's something that we do, Ken and I do in our focus groups is, for me, I do, a number of different types of, variations of focus groups. And one of the ones that I do early on, after a concept focus group, if you're deciding whether you're going to keep a case or not, we do discovery focus groups to decide, what evidence, what testimony is necessary, what testimony and evidence is effective, what's not effective. You know, the worst thing that you can do, and believe me, I mean, I've made this mistake over the years too, is not vetting, you know, a blow up that you have, or not vetting a particular witness testimony well enough, and you get to trial and they end up, you know, torpedoing your case when it could have been prevented if you had vetted it before. So that's a big one for me, and I do it in my own cases all the time.
Yeah, me too. And with the discovery focus groups we do, essentially we're trying to find out what a jury's gonna want to learn, right? The worst thing that can happen is you try a case and you come in second place, you get that silver medal, right? Not that good. You come in second at trial, and the jury said, if we only knew,
Right.
we
We
only
always had this. Yeah.
So find out beforehand. And one of the ways we do it, we ask folks when we give them a summary of the case. It can be really early on. I fully understand that we don't know all the facts yet. I get it. Some lawyers don't want to do a focus group until they know everything. Be open to the possibility of giving what you have, even early in the litigation, to a focus group, and basically say to them, your job today is to get to the truth. You have one job. Who would you talk to? And what would you ask? And then we role play some theater aspect. We'll have a lawyer play the role of whoever they mention. They might say, okay, I want the name of the, you know, responding police officer. Okay, Officer Smith is here. What would you ask her? And I say, who else would you want to talk to get to the truth? And what you do is you're finding out what people want to know early on. And sometimes it's things that you never would have thought of. Certainly, sometimes it's issues and facts that we all get. I understand that. But occasionally I'll be in a deposition and there'll be a break and my opponent will say, Ken, what was that line of questioning you asked? I mean, what was that deal about that truck driver? What? And I'll say, well, it's something I thought would be important. I came up, you know, with these questions. A lot of times I come up with the questions because the focus group told me that's what they cared about.
That's right.
And like Lauren alluded to, it's not about us, what we think, not even what our clients think. It's what the ultimate decision maker, the 12 strangers in Chicago, they're going to make my client's life miserable or pleasant, right? It's what they care about.
Mhm.
So don't be nervous about doing a focus group early in the case and finding out. Sometimes Lauren talked about exhibits, see if it resonates. Sometimes you'll spend a lot of money on a great maybe animation or visual and you fall in love with it. This is perfect. Show it to a focus group and they say, I don't understand it. It's confusing and I don't like it. What does this mean? And you might want to, you know, discard it.
Mhm.
But
Change.
it's, even though you spent the money, it's hard to do that.
Mhm.
But if it's best for the case, do it. Even showing a day in the life video later on in the case to a focus group, they might say, you know, we had one that they thought was too long. They're like, we don't need to see him eating with that spoon fork thing. They're like, we didn't see that. We didn't. Okay, great. And I tell them, your job is to be Steven Spielberg here. This is 8-minute day in the life video. Let's edit this down. What if you're the storyteller? What needs to stay? What needs to be added? How would you change it? Isn't that great feedback before the actual jury trial?
Yeah, that's, I mean, you know, it becomes such, I mean, it to a point of invaluable information that you can garner from these focus groups. And, you know, people will tell me that are sort of skeptical about running a focus group. Well, but every focus group you get, if you do more than one, or, you know, is going to be different from each other, and they're going to be different from, you know, what the jury does. Yes and no. You know, it's not necessarily so. A lot of times I'm actually running a series of 3 focus groups for the same case, starting very early on. And we did a discovery one. And one of the things that we found was that there were, even though we had different jurors, there were a lot of consistencies in how these jurors were approaching the information that they were provided and how they, you know, thought about the case. And, you know, so I think that there's statistics all over the place, but by and large, when you're asking the right questions of the focus groups, you're going to get answers that are going to be extremely valuable, because even if you're like, at the end disappointed that, you spent all this money on an animation and the jurors are, your focus group is saying, this is not working for us, you're going to save money later on, because maybe a jury later on is going to say, hey, you know what, we're going to discard all of that information anyway. And, you're going to find that you probably would have been better off taking the settlement versus, pushing yourself all the way to trial. And, you also find out, even simpler than the expensive exhibits and the expensive evidence, we found out second focus group in a case where you'd imagine that, we always talk about showing, the client's activities in their life before their injury. And so we're showing the jury pictures of our guy is out with his friends, taking a selfie, quadding in the woods. They're all, peace signs to each other. And one of my jurors throws her hands in the air and she goes, huh. I said, all right, got to stop and find out what this is about. I said, why the reaction? She's like, well, now I know why his neck is the way it is. Do you know how hard it is on your body to, to go quadding in the woods? So it wasn't the fact that a ceiling fell on his head that caused his injury. It was the fact that prior to the accident, he was quadding in the woods with his friends. So, and they all the other jurors said, yeah, that's true. And all of a sudden they fell down a rabbit hole talking about, the burdens on your body from motorcycles and quads and so on. And we realized perhaps this isn't the most effective photograph. Maybe we just talk about it rather than show it. So that was pretty valuable, because the jurors went a completely different direction than we would ever have expected them to do based on a picture. So it was information that was very valuable to us in the end. Why don't we skip ahead to our next topic? Oh, we have questions here. Let's see. Do we want to jump into these questions, Kim, or you want us to keep going?
We can entertain the ones you want to. There was one question from an anonymous attendee. Any examples of questions for voir dire?
Well, yeah, I mean, it depends on the case. That's one you have to write to me about or write to Ken about. We can talk about a little further. But, one of the things that I find when I'm helping attorneys out of state with this sort of thing is trying to establish the standard of care. And this often happens or works well with nursing home cases or medical malpractice cases, where the answer isn't so obvious. But, when you ask a question, for example, we know what the protocol is or the standard of care is for, checking on a patient who is bedridden to prevent any sort of subcutaneous ulcers and the skin ulcers. And so, we know, it's, so many hours, they have to be in a chair, out of a chair, et cetera, et cetera. But, you can ask questions of when you can ask questions of your jury and ask them, what they think the more appropriate protocol. What would they do if they were the running the hospital or the nurse? What would they do? Or how would they go about it? And you kind of can narrow down what their standard of care is going to be. Because a lot of cases, the standard of care is going to be, a lot more strict than A, what the nursing home did, or B, what the actual standard of care is. So, knowing being fully aware that jurors have their own rules, that's sometimes a better way of finding out what sort of information you need to give them to get to that end result of them applying their rule to the facts of the case. So that's one of the things that we talk about.
Okay, and we are at 11.
I was going to answer one more question. I think H. Lee had one about how do you show the plaintiff is a victim, not a victim,
That's a good one.
without taking away damages. And I guess I would pose the question the opposite way, which is if you show your clients a victim, your damages will be less.
Mm-hmm.
Nobody wants to give money to someone who's whining and complaining and negative and sort of a Debbie Downer, right? People want to give money so they can be of help to someone who's helping themselves. So I look at a victim as someone who just everything's negative and a black cloud hanging over their heads, as opposed to a victor, which is all the ways they're trying to help themselves. So sometimes, I remember when I was a younger lawyer, I was trained, lost wages are great. If they're off work a year, that's even better, year and a half. And now, as a more experienced lawyer, I want my clients back to work as soon as they can. So I had a truck case, we do mostly truck work, and this truck crash survivor, not a victim, survivor, was off work and it was the middle of the pandemic. I said, you gotta do something. He said, oh, I'm in pain. I have all these, I had surgery. And I said, I know. But people are off work now, or they're online doing something. You got to get something online. I don't care if it's 15 hours a week doing something to help yourself. And I said, what do you do? I mean, if you can't work, I get it. But I think it increased the value, even though logically there's less lost wage claim. But it shows that he's helping himself, and nobody wants to help someone, jury, unless they're doing something for themselves. Why should I give money to this person who's not even helping themselves? So lost wages are a nice way, getting someone back to work, getting someone to do things for themselves to help, as opposed to missing appointments and sitting around doing nothing. That I'm done with that rant.
Rant over.
That's good. Someone's asking that you copy and paste the list of mistakes in the Q&A so that they can easily copy those. So I need one of you to do that. John Tierney is asking, can you discuss types of focus groups and how you set them up, costs, just some of the specifics on that?
Sure. Hi, Jay. For me, I try to mold whatever focus group we're going to run to the issues in the case and where it is in procedurally in terms of discovery, whether we're just starting out. So the types that I do, which I think is pretty similar to what Ken does as well. I've run concept focus groups, which are focus groups that really, as the term says, focus on larger concepts in the case. These could be for the purposes of discovering whether or not the liability is worthwhile for you to go forward. These can be, a lot of times we do these in cases where the damages are catastrophic, but perhaps the liability is a little bit questionable. A lot of times in trucking cases, this is the situation. So we want to find out from the jurors, we want to find out themes. We want to find out the things that are important to them, what information they want to know, and how they feel about the issues of liability and causation. And then we might get into damages. I do discovery focus groups, which are sort of part and parcel with concept focus groups. And that's, as we already discussed, those are focus groups that are designed to find out what information we need, what evidence do we need, what witnesses do we need to hear from, and more importantly, what is it we need to get from those pieces of information to make the case successful in terms of presenting it to a jury. Structured focus groups are a little more formal in that we're providing both sides of the case. So we have either I do it or I have the attorney participants performing their, we call it a clopening statement. Essentially, it's an opening statement, but it's got some argument in it. So it's kind of a hybrid opening closing. And they provide that information and the arguments to the jury, and we let them deliberate. And then we sort of sneak in information and evidence and let them continue to deliberate on the issue. So you're getting more specific answers in terms of how they feel about a case. And then I also will run a mock trial, which is exactly what it is. We set up both sides, we set up the jury, we set up a judge. And this allows for especially young lawyers, it's great because it helps them practice whatever it is that they need to practice. Sometimes that we can bring in, if you have an untested expert, we can bring in the expert and see how they do. I don't run those as often as I used to, though. Those used to be the ones that people used to ask for more. But I think, Jay, you asked about price ranges. It depends. I run, most of my focus groups are either a 3-hour adventure or a 6-hour adventure. I can do them virtually. I do a lot all around the country virtually, but I also, I'm back to running in-person focus groups as well. So as Ken does, Ken's traveling all the time to meet attorneys and run these focus groups all over the country. I don't run as much. I'm more on the Zoom these days. But Ken, what else? I mean, price wise, I mean, they really
It really varies. It really varies, right?
We like to work it within your budget. That's what we like to do.
Yeah, it depends. And everything, Lauren and I do all the same things. And another couple things you want to do is just test. To me, it's about testing.
Yeah.
Video clips of expert witnesses, your client, literally get your client on video. The 3 questions I like to ask, tell us about yourself. You want to get a reaction, what people think of your client. 2, tell us about what occurred, maybe the incident, and then 3, how has this crash or incident affected your life? Let them go on to damages. And then we're trying to see what resonates with people. Mark Mandel's written a couple great books on case framing and, what factor issue a jury can't get over. That might be the key to your case, your theory, focus on the case. But a lot of different types of focus groups. Your creativity is your only limiting factor. But yeah, reach out to Lauren, reach out to me. We'll be happy to help you. I want to talk about Patrick's Levy's question. Can you talk about strategies for limiting comparative fault in tough cases, premises, motorcycle cases? Great question. Using focus groups could really frame these issues. I find the jury bias model that David Wenner, Greg Cusimano helped develop years ago, and a lot of us have worked on, is key here. And that means looking at the case from the defense perspective and the choices, decisions the defendant, company, or individual made carelessly or they could have done differently. If you frame the case from the point of view of all the choices defendant makes, I think that helps limit comparative fault. And then I love the way you used limit comparative fault, Patrick, because it's not saying that it's 100%, because I think certainly there's 5 states that you're going to lose if it's 1%. In most of the cases we work on, I think being honest and saying, look, my client has some responsibility here. There is some shared responsibility. It could be maybe they're speeding a little bit, maybe they did something, but compared to the defense, and I think being honest and suggesting a smaller number for your client's comparative fault is more credible and works better in getting a fair verdict than say, oh, it's 100-0 if the facts don't justify that. But there's a lot of ways to test and limit fault.
Yeah, that's over. I mean, that would be overreaching just, in a case where you're suggesting that, there's no comparative fault at all on your client. That's a case of overreaching, and it never really resonates well, because the jurors want someone to be accountable. They want someone to take responsibility, and they like when you say, look, I know I should have had my left turn signal on and I didn't. But, being able to, exactly as Ken said, being able to embrace that weakness of the case and say, look, exactly, we know we have some fault here, but comparatively speaking, here's all the things that they did wrong. And really, the key here is focusing on what the defense did wrong, or whatever omissions that they did. Because, if you start that conversation right from the beginning, right from the opening statement, talking about the defendant's actions and what the defendant did or didn't do, that led to, what's happened and why we're all here. That's an effective way to start framing your case, so that when we get to the point where, your poor clients cross-examine about their left turn signal or whatever it is, they've already heard it. We know, we already know, and we're not that mad at him because you guys did this. It's a longer list of things. All right, so you want to, Ken, why don't we talk about a little bit about how our focus groups arrive at damages?
Sure. I mean, I look at, we mentioned Steven Spielberg earlier. I look at my job as a trial lawyer. I'm Steven Spielberg, right? There's a lot of scenes we can use, but we got to edit it down and come out with the most compelling ones. Telling the best story usually means you're going to win, right? I mean, it's not about the facts and data. It's about a compelling story that elicits a response from the jury that they want to help. They want to help this poor working family that was put in this untenable situation through no fault of their own, and they need help. They need your help. Working with sometimes clients aren't the most likable initially. You got to work with them and practice and test and figure things out. But a compelling story is so important. You can test those with focus groups. And when the first day we meet a client, we're thinking about the trial story. What was taken away and how we can replace that with a good verdict, a just verdict. I can't emphasize storytelling, reading books on storytelling or screenwriting and framing your case. And again, a life story is, by definition, a long time. But in a trial, you have to limit it down to the most compelling facts or scenes. I'm looking for, if I'm making a movie about my client's case, what would be a compelling scene that shows what our clients went through or shows the liability portion, and that greatly helps with our damages.
Absolutely. And, we listed here a couple other issues that sort of help our jurors come to, good conclusions. One is anchoring, and anchoring is sort of throwing out numbers that the jurors can use in their final deliberations. For example, millions of patients come through this hospital every year. Millions of people drive on this highway every year. In New Jersey, so we're very limited in New Jersey. That we have any success at trial is sometimes, overwhelmingly, questionable. But we have, we also, in addition to not being able to conduct significant voir dire, we also can't ask for an amount of money to help our clients. So we can't ask, we can't suggest any amount of money. We can't say, we're suing the defendant for $12 million. There's none of that in New Jersey. And I know there's, other states like that too. So that's an added challenge, but it really isn't, because, at the end of the day, there's a lot of other things that we're able to use, like per diem type arguments and so on, that help, the jurors anchor to a number. And then the final thing I wrote here is the juror compromise. And really what it comes down to is when we do a focus group and we get to damages, and this is usually like the last, end of the focus group, and, and no matter what happens, they go, oh, I don't know how I would do this. I don't know how I would come to a number, but they always do. So write down a number based on everything that you heard here that you think is fair and reasonable, that would compensate the injured plaintiff. Okay. So they write it down. and they put their papers down, and then I go around the circle, and despite what they wrote down, whatever seems more reasonable on the other side of the table, that's what they go with. So they might have written down $250,000, but the first person says, well, I think $650,000 would do it, and here's why. Now, suddenly they don't feel like they're smart enough or they're adequate enough as a juror, so they're not going to talk about what they wrote down. So in a lot of instances, what that really means for us is that, despite everyone having an individual opinion about what a case is worth, unless that particular juror is considered a leader of the group, the likelihood is that their feelings are going to get molded into everything else. So now they're saying, well, 650 might be high, maybe 500. And they're all saying, yes, maybe 500. Meanwhile, they've all written $5 million over here, 150,000 over here. Like, it doesn't matter what they thought, because it becomes this great juror compromise. So we always, try and figure out, how they got to where they got to. And a lot of times it's exactly what the judge says don't do, which is compromise. So just to throw that out there. So, it's important and that's why this anchoring is important. That's why the compelling story and the likable clients is so important in our cases, because you have the great compromise in the end. Let's see what else we have.
One final point on compromise, liability and fault affects damages.
Yeah.
In law school, we're trained to issue spot, figure out the fault, and then move on to damages. But a lot of times we see in focus groups and actual jury trials, someone will say, yeah, we're giving $1 million in this case, but he did, make that lane change, and they go back to fault. So all the more reason, make your liability portion of the case as strong as you can.
Yeah, that's
because people are going to go back and say, well, look, I'm not giving $1 million or $5 million when the plaintiff did X. But if you can hammer home liability, you're going to get less compromised down from your damages, and vice versa, right? If you can get some egregious facts, even though punitives aren't technically on the table, I think a jury is going to get more fair and just verdict. And Lauren Fraser lives in a part of the country that, despite the fact that it's a blue state, is very conservative. Her area where she practices and tries a lot of cases. So Lauren, why don't you take some of this slide, and then I'll chime in if you need me to.
So, and these photos were from our family vacation last year to the Nickelodeon Resort in Dominican Republic. We're big SpongeBob fans, because who's more pleasant and happier than SpongeBob, right? So, some of the things that we've picked up from our jury focus groups and from my own trials and tribulations as well, are the things that connect with, our more conservative jurors. And we're always looking for the ideal juror. And I've sort of gave up many, many years ago and said, there's no ideal juror. We just have to deal with what we have and figure out how to reach them. So some of the ways that we've been reaching our more conservative jurors is focusing on themes like freedom. You know, where I sit in facing my jury, you know, we're choosing a jury, you know, 15 of them come in with like a MAGA hat on and you're like, oh my God, you want to pass out. But, you know, at the end of the day, it doesn't really matter because people are people. And if you can reach them, if they have a heart and they, you know, you've put on a compelling story for your client, they're going to want to help no matter what hat they're wearing. So freedom resonates on so many different levels. You know, think about what's worse than, you know, losing your freedom. And you think, well, how do you lose your freedom? I mean, this guy was just rear-ended in a car accident. How did he lose his freedom? Well, he lost the freedom to decide how his day would go because, you know, it used to be he would just, you know, go to work, go to the gym, do what he wanted to do. And now he can't go to the gym anymore because when he does go, he's in intense pain afterwards and he really pays the price. So he doesn't have the freedom to do what he wants to do. He doesn't have the freedom to not have to go to the doctor, to, you know, live his life pain-free. You know, he's staring out the window at everybody else while, you know, his family is out there on vacation and playing games and having a good time. He doesn't have the freedom to live his life the way he imagined he would live his life. So that's even on the, you know, the smallest scale. That's a theme that has really worked with our focus groups. And it sort of came out of the research that we did while we were all shut down during COVID. It just sort of clicked. Showing, don't telling. Showing, don't tell. Really, the jurors that are on the more conservative side, they don't want you to tell them what to think. They want to see it and come to their own conclusions on their own. So bringing them MRI films and showing the damage to the spine, or showing them the x-rays and where the hardware is on a person and why that's a problem, having your expert explain why that's going to be a problem in their life while they're staring at it, you know, the size of a barn door, is very compelling. They don't want to be, you know, you can talk about it. And the defense, you know, the defense doesn't want to show pictures. They don't want to show, you know, the actual truth of what happened to one of your injured clients. So, you know, it's important that we show them those things. Talking about joys, harms, takes, you know, we talk a lot about, you know, you have got your pain and suffering. We've kind of moved away from using pain and suffering. We talk about harms and losses. And our friend Michael Leserman talks more about takes, the things that are taken away from a person. Because there's a difference. And if you think about the analogy he always uses is, you know, losing your cell phone versus someone taking your cell phone away from you. Losing your cell phone, you go find it, you know, you can get it back, but someone takes it away from you, it's a whole other level. So we talk about, you know, the things in a person's life that brought them joy, you know, that'll probably resonate, you know, across the board, whether it's children or charity work or, you know, physical activity that brought this person joy prior to this accident. And now that's been, you know, along with freedom, that's been taken away through no fault of their own. So, you know, it's sort of the juxtaposition of emotion in that, you know, jurors are very much motivated by stories of hope and joy. And they, you know, they want to help the person that was hopeful that they would get better, that was hopeful that things would turn around for them. But they're also going to, on the other end of the spectrum, you know, they're going to find anger for your client when things are taken away, you know, through no fault of their own. So those are some of the emotions that we talk about. And then one of the hot, you know, topics in terms of, you know, in our circuit of trial consultants is, you know, the idea of heroes versus villains. And our friend Jesse Wilson talks a lot about this and does a great job. And he, not unlike me, also has a theater and acting background. So we kind of come from the same place with this. And the idea really is that, you know, you're presenting the trial story and your client as a hero. They are someone that, you know, should be, you know, maybe they're a reluctant hero, maybe they're an unlikely hero, but they're someone that you want to, you know, at the end of the case, cheer for and say, yes, we want this guy to succeed. We want him to do great. And then there's villains. Villains are the bad guy, obviously, but we have to be careful because, you know, Grandma Myrtle, who, you know, backed out of her parking space at the Walmart and runs your client over, who was on her way to, you know, a charity event, you know, for bingo at the church, probably not going to appear as, you know, the villain that we might hope she would be. So we have to be careful that we don't polarize the jury by, you know, overreaching and overstepping our bounds with villains. But when I think of villains, I think that the best way to use this sort of idea is when we're dealing with corporate defendants. A lot of times, unfortunately, the trucking companies, you know, retail stores, you know, big conglomerations. when we are truly dealing with, profit over people, that's when you can really create a villain story. And Ken, maybe you can weigh in a little bit on the villains, because I have a hard time, calling grandma who, ran into a client a villain,
That's
but
right. That's right. You got to be very careful of individuals, especially versus a corporation. And sometimes the villain is the system, right?
Yeah.
If they allowed occur, it can be a systematic failure that the corporation allowed to happen or implemented. That could be a better source.
Yep.
But I guess one of the lessons we've learned, especially Lauren, is don't be scared of a conservative juror. Sometimes they're your best friend. I mean, some of the best verdicts I've gotten, I tried a case with our friend Michael Leserman. He was a lead lawyer in a truck case that was in federal court in Arizona, very conservative venue. And we had a $13 million verdict.
Mhm.
The offer was like 500,000. Conservatives will give fair verdict or fair verdicts, fair money. And oftentimes in our truck cases, you'd rather have a conservative rule follower
Mhm.
who's going to be less forgiving of a federal reg violation than a maybe arguably a liberal juror who's more forgiving of a rule violation. So depends on the case, focus group it, think it through, test it, use your strategy. But we had one just recently with a juror with a red Make America Great hat. And I was worried initially, but she was by far the best plaintiff's juror in that case. On liability, on damages, on rule violations, she was phenomenal.
Mhm.
And politics didn't really seep in other than her wearing the hat. So there's a lot of great themes. Freedom is a key one, but there's other themes that resonate with jurors about rule following and government controlling. I mean, they have the power as opposed to the government or bureaucracy. Some conservatives like that choice issue and being able to make that decision, but as opposed to the government telling them what to do. And that could apply in cases where maybe a road construction case where the Department of Transportation of that municipality approved plans that the construction company used. And they're like, hey, it was approved. The government said we can do it. A conservative might say, I don't care what the government said. That was wrong. That was willful and wanton and reckless to have a highway design that way or construction site that in that circumstance. So sometimes they're your best friends.
Yeah, absolutely. Let's see what we got left here. Well, running focus groups, we already kind of touched on this, and this was the cast of my my theater or my students doing SpongeBob last year. Books, Ken, I look forward to your emails constantly telling me what I should be reading and what's out there. And that's one of the things that we talked about early on was that, we're reading things, none of these are lawyer books. These are all books about sociology and psychology and happiness and things that we, need to know in our lives anyway. So.
Absolutely. We love doing it. So we try to read a book or two a week on decision-making, psychology, metaphor, storytelling. Shoot me an email if you want to get a monthly email. And more importantly, selfishly, let me know what you're reading that's helpful for you in your practice and life and getting better and improving, because we can all help each other and help our clients.
Absolutely.
Those emails with the book recommendations are very helpful.
Yeah, they're great.
And I'm reading them, Ken. Reading a lot of
Thank you. Let me know what I should be reading in addition. So thank you. My son Sam used to play basketball as well.
There you go. Yeah. So I mean, reach out to us and we can help with your focus groups. We love to workshop cases. If you're not ready for a focus group, you want to sit down and work with us on, creating opening statements, closings, working out questions for your experts, questions for your clients, training and helping to, sort of train the clients in terms of their own presentation in a courtroom. As you probably know from Ken's social media, he loves to eat. So do I. So, if we're around in your city, in your town, look us up and, hit us up for a breakfast, lunch, or dinner or happy. We also love free food as well.
Absolutely. And can I make one shout out? They can have a meal with us in Phoenix. Lauren and I are co-chairs along with Jeff Boyd in Seattle of AAJ. If you're not a member of AAJ, please join. Best trial organization for advocacy and public affairs and everything else we do. Join AAJ, and we are co-chairs of the Jury Bias Litigation Group. And we talk about all these issues, oh, it's a great photo, about how jurors make decisions and the biases and how we can tap into psychology and framing and all the things that Lauren and I have been trying to help today about and talk about. So join the Jury Bias Litigation Group. Any thoughts on that or issues, questions, call Lauren and I, because we'd love to learn from you as well.
Yeah, absolutely.
And don't forget to learn from your actual jurors, not just those in focus groups, but grab as many of those people as you possibly can. That was a wealth of information for me for 27 years. I grabbed as many of them as I possibly could. Still in my work now, use a lot of what I learned consistently from them.
That makes perfect sense. So Kim is advanced for 27 years. She's been doing this since she's been 6 years old. So God bless Kim for 27 years. As a child, she started learning from jurors.
My 40th year this year. So I know. Someone's asking, what is the contact to join the listserv for the Jury Bias Group?
You have to be a member, and once you're a member, I think they put you on the listserv. But email me privately if you're a member of the Jury Bias Litigation Group. I think you should automatically get on the listserv.
Okay, and I've got Ken and Lauren's emails on here. They also wanted you guys to put the list of recommended books in the Q&A. So if you've got that in a format where you can copy and paste that into the Q&A, Lauren.
If you like, some of those are a little not outdated. I recommend it, but email Lauren, email myself. I'll get you dozens of books.
Yeah, Ken has the running list of books that I'm reading too. So get on his newsletter, and he's got great recommendations for you. I mean, the ones that were on there. I mean, the ones that I always suggest to read are, Malcolm Gladwell, always Malcolm Gladwell. He's an author that we really look to. For sure, but yeah, Ken's got the master list of all of those things. So
yeah, I keep a running list, and one of the writers he's written a few is Robert. I think I'm pronouncing his name correctly. Cialdini. I think he's a professor in Arizona. He wrote a book on influence, persuasion. He's written, I think, 3. Robert Cialdini with a C. He is phenomenal.
Okay, so for my anonymous attendees who are asking about a code for the seminar and the list of books, email Ken directly for those and get on those lists and get direct responses to those. And again, their information is in the Q&A, and in the chat, I believe you can pull up the list of email addresses for everyone that's involved with this, whether you need to reach out to Ken, Lauren, or somebody at Case Metrics. And I think we have handled all these. We did keep you guys a little bit longer, but man, with people being so well engaged, we like to keep the communication going. Thank you very much to our co-hosts, Lauren and Ken. This has been very enlightening, as I knew it would be. Do feel free to reach out to Lauren at lfraser@lawjw.com or Ken at levinsonstefani.com. Also, you can reach out to me, Kim.White at case-metrics.com, or to Michelle Connolly in our office, and that is Michelle.Connolly, CONNOLLY at case-metrics.com. And we can continue the conversation afterwards and make sure that we put you in front of the correct folks to get the information that you still need. Thank you very much for joining us. Happy holidays to all of you, and be on the lookout for our next webinar. Thank you very much.
All right. Thanks, everyone. Take care.
Thank you.